By way of introduction, I'm actually, before I get started, I'd also like to acknowledge the traditional custodians of the land and pay my respect to the elders past and present, and extend that respect to all Aboriginal and Torres Strait Islander people for allowing us to meet on those lands. So just by way of background, I am an academic, but I used to be a practicing lawyer. The areas that I practiced in were property development and property finance, and that practicing experience ranged for a little bit longer than a decade, so about 12 years. Since leaving private practice, I have joined Griffith and, as Therese said, completed my PhD. And my area of research and my area of practice has been in strata title law. So the research has looked at the intersection of property rights and community interests. And I've looked at that in the context of community titles terminations, disclosure for off-the-plan sales, the sharing economy and the regulation of the sharing economy in strata schemes, and also the regulation of management rights contracts. And that's obviously what we're speaking about today. I'd always approached management rights from the opposite perspective to what this paper is written on. I'd always acted for developers in the establishment of management rights, and for both bodies corporate and managers in the review of the agreements, the extension, the transfer, and those sorts of things. So when I started looking at this area, it came as a bit of a surprise to me, given my practicing background, to see that there was such a divergence in what my worldview of the industry was compared to what the research was telling me. And so the research really gave me the opportunity to look at what happens in community title schemes after the developer exits the scheme, and and really sort of see that there was an issue there. So for those of you joining us who aren't familiar with community title schemes, then I'm just going to run through a basic overview for you. So for those of you who are familiar, please bear with me. Our regulating act is the Body Corporate and Community Management Act, and that's been in force since 1997. It replaced a number of predecessor acts, most of which are actually still in force because of the different schemes that they apply to. But management rights in particular, I'm particularly concentrating on the BCCM Act. Now, the Act provides for the establishment of a number of regulation modules, and each of those modules are listed up there on the screen. Now, you can see the numbers that are written underneath those modules, and you can see that the accommodation module has 25 years, and the small schemes and two lots module has 1 year. Those are the lengths of appointment permitted by the various regulation modules for management and letting rights contractors. And in particular with the two lot schemes, it's the appointment of service contractors that's actually permitted. Now, in order to create a community title scheme under the Act, you need a minimum of 2 individually owned lots and property that is used in common. Now, that property could be, for example, a shared driveway, or it could be a shared wall or a roof line in the context of a duplex, or in the context of a high-rise building, it could be the lift wells or the car park underneath the scheme. In a townhouse complex, for example, it may be the swimming pool and the gymnasium, those sorts of common facilities. But it also is the common utilities as well, so the shared sewerage piping, the plumbing, the the HVAC system, all of those sorts of things. And so a community title scheme can be as simple as 2 lots and a shared driveway, or it can be as complex as a mixed use, multi-stage, multi-tiered management system. In order to create the scheme, the developer will lodge the survey plan, which sets out the boundaries of the property, as well as the community management statement. And that community management statement contains information in it that allows for the management of that scheme. It contains the bylaws. It also contains the percentage contribution that the lots make to the shared costs of the scheme, and the percentage interest that the lot owners have in the scheme property. So, for example, if the scheme were to burn down, the percentage of the insurance proceeds that they would be entitled to. It is managed by, simultaneously with creation of the community title scheme is the management entity that's created. So when you see body corporate for CTS 1, 2, 3, 4, 5, 6, that body corporate is the managing entity. The CTS is the actual scheme and the scheme land. So that body corporate acts through two avenues, either the lot owners, who are the members of the body corporate, and that's for high-level decisions with a high level of spending, or the committee, in the same way that a board of directors acts for a corporation and the shareholders decide certain issues. It's the same sort of conceptual arrangement that a body corporate has. Completely different legislation though, so that the duties and obligations are not the same. And similarly with the variation in schemes, the variation in management structure can be very diverse. The management structures are essentially as complex as is necessary to manage the scheme. You can have multiple layers of management. You can have body corporates within body corporates, and you can have various contracted stakeholders and management arrangements that are set up. The key point to note with all of this is that it's the original owner, the developer, that establishes the whole thing. It's the developer that conceptualizes the scheme, designs it, creates it, and eventually creates the management structure and the CTS arrangements and all of the contracts that go with that arrangement. And so they, as the initial sole owner of the scheme, will actually procure the body corporate's agreement to enter into a lot of these agreements. And that can be the management agreement, so the administration of the body corporate, the person who looks after all the paperwork and the budgeting and all of those sorts of things on behalf of the committee. Or it could be the person who sits at the front desk and looks after the rental of lots within the scheme. And the latter part, although not that aspect, is the one that I'm concentrating on today. So what my research has related to is the establishment of management and letting rights. And that is made up of two different types of agreements. And the first one is the caretaking agreement. And that caretaking agreement is a contract with a fixed term. As you can see, the 25 years for accommodation standard module is 10 years. And that contract has a set payment amount. And during the term of that contract, the remuneration is typically reviewed on an annual basis. And it's usually the higher of CPI or 5%. And so whatever the contract amount is at the beginning, at the end of the 25 years, it's going to look significantly different if you've got 5% reviews being placed on top of it every year. The management agreement also contains a list of duties, and that out of the most recent project that I've been working on seems to be where the issues lie. The idea of a caretaker is that they look after the day-to-day management and maintenance of the scheme. So things like cleaning the swimming pool, replacing any globes that need to be replaced in a way that, that you don't need a specialised tradesperson to do it. Looking at cleaning of lobby areas or lift, those sorts of things. So, you know, it's the day-to-day stuff that they look after. Basic landscaping as well is often included. The second aspect of management and letting rights is the letting authorisation, and that's where you have the person sitting at the front desk in the lobby when you walk into a high-rise building, or the person in the manager's unit when you walk into a townhouse complex. Now, what this agreement does is authorises the exclusive letting of lots within that scheme. It does not bind the owners in the scheme to use that letting agent to rent out their lots. What it does is authorises them to sit at the front desk. It gives them an exclusive opportunity to sit at that front desk. So there's no fee that's payable by the body corporate to the letting agent for that authorisation. It's merely an authorisation. In principle, I don't have an issue with the idea of management and letting rights. It actually fulfills an important role in the administration and management of a scheme. But what it does, or what has happened, where the issue lies, is the legislative changes that we've seen over the last 20 or so years that have swung the pendulum in the direction of the original owners, the developers, and the management and letting rights industry. So those caretakers and letting agents, and the caretakers and letting agents financiers, at the expense of the body corporate. And so that's where you know, my research lies. Now, that's a pretty big claim to say that legislation actively disfavours an entire group of stakeholders. And, you know, how do I back that up? So the objective of the Act is to provide flexibility to the body corporate in its operations and dealings to manage the common property and the body corporate assets and the administration and management arrangements. But original owners hold a broad discretion to establish and sell management and letting rights for a scheme. They're the ones that set everything up. The legislation allows the original owner to do that, to keep the proceeds of the sale, and to contract the body corporate into what is potentially a quarter of a century worth of contracting. And that's entirely separate to the extensions that are requested on an ongoing basis. That's actually pushed by the financiers of management and letting rights. So the original owner sets up the development. They also set up the community management statement. That community management statement is where you dictate what regulation module you're choosing. So the developer simply says, we're going with accommodation module, or we're going with standard module, or we're going with small schemes. They have the absolute discretion there to choose. Now, in saying that, that discretion is limited, and I'll go through what the requirements are in a moment, but what the regulation module does is determine the length of the management and letting rights. So the accommodation module can be chosen when the original owner evinces an intention upon its registration that the lots will be predominantly accommodation lots. So in other words, lots used for short or long-term rentals or as part of a hotel. The choice of the regulation module by the original owner, however, acts as a self-fulfilling prophecy, because all that the developer needs to do is announce it in the disclosure materials and in their advertising that management and letting rights is intended to be adopted for the scheme. Because by doing that, the original owner is evidencing an intention that the lots are suitable for investors and that they can be rented out. And so by evidencing that intention, you're then justifying the choice of the regulation module allowing for a 25-year contract. The lots are anticipated to be rented because they are advertised as being able to be rented, and so they can be rented and it's a vicious cycle that the body corporate is stuck in. It becomes a convoluted self-benefiting justification, and what it does is enables the original owner to receive the benefit of a premium sale price. The standard module, which is the next level down in terms of length of contract period, is 10 years. So the original owner has the motivation to secure an extra 15 years of contract term by going from the standard module to the accommodation module. And what does that do? Translates into sale price. So if the original owner can evince an intention that the lots are going to be rented, they can choose the accommodation module, which means that they can get a higher sale price on the management letting rights. And the original owner is the one that keeps that sale price. So in property law, there's a long-standing principle that's called the dead hand principle. And what it says is that lot owners, it's undesirable for lot owners to be controlled by predecessors in title. That is exactly what the legislative system created to facilitate management and letting rights does. That predecessor in title here is the original owner. It's the developer. And the problem that we have is that these original owners can embed dysfunction into these schemes right from day one. They have the ability to sign up a contract that will last for 25 years, or best case scenario, 10 years, to allow them to sell the management letting rights. And the body corporate is stuck with it because they enter into these agreements as the sole owner within that first period of time that the body corporate is created before the sales of all the lots go through. There's zero oversight in this. Developers do not need to answer to anybody in doing this. And so my argument is that the progressive amendment of the Body Corporate and Community Management Act and the regulation modules to increase protections for the management letting rights industry and their financiers, and in particular giving the flexibility to the original owner to set all of this up, has affected the body corporate's ability to control its own affairs going forward. So then why is this important? Well, service contractors, including management and letting rights contractors, are engaged by the body corporate to supply services to it for the benefit of lots and the common property in the scheme. And the specific duties that have to be performed are set out in these agreements. The original owner, via their lawyers, are the ones that develop these agreements. They're the ones that, the original owner will literally ring their lawyer and say, I'm selling management and letting rights with this scheme, draw me up a caretaking contract and a letting agency authorization. And that's what a lawyer does. They include it in the off-the-plan contracts, and then the caretaker gets the salary and everything once it's all created. The original owner also dictates the salary that the caretaker will receive. And they will do that based on market forces, but arguably the market forces are out of whack in terms of other developers setting these levels at if the agreement terms do not reflect the work that has to be done or the extent of work that has to be done, then the salary is also not going to reflect what needs to be done. And so there's a divergence there as well. And as I said, the developer is the one that sets the salary, the developer is the one that sells it, the developer is the one that receives the sale price. The sale price is factored based on the length of the agreement, the caretaking salary, and the percentage of commissions that are expected to be able to be achieved from the rental of these units. And so once again, it all comes full circle back to the one entity creating and getting the benefit the short-term benefit from these contracts. Arguably, from a developer's perspective, it's appropriate for them to retain the sale price because they're the ones that are wearing the risk of setting up the development. They're the ones that are spending the potentially hundreds of millions of dollars to create this development. And so their argument has always been, well, we should be able to set these up and we should be able to profit from it because we're the ones wearing the risk. But they're wearing the short-term risk as opposed to the long-term obligations. And when you look at development interstate, we don't see the same level of management and letting rights in New South Wales and Victoria and the other states in Australia and territories in Australia as what we do in Queensland. But development in Queensland is not unique. It's not, we don't have special buildings that you don't find it in any other jurisdiction. I mean, we do have some climate challenges and the need to build, hurricane-proof buildings and those sorts of things. But the development industry itself is, common throughout Australia. So what's the difference? The difference is the legislative system that enables these contracts to be set up. And so what you have is the short-term cash injection that the developers get leave the owners with long-term obligations that they are then stuck with for the length of the contract. Now, the ability for a developer to set these things up is not completely unlimited. There are obligations on a developer to act in a particular way. And Section 112 of the Act contains an obligation on the original owner regarding contract entry, specifically for service contractors. However, the penalty for non-compliance is about $40,000. These things sell for tens of millions of dollars. The fine, the stick is not commensurate to the carrot. There's a very, very big carrot here. And so the other issue is that because there is no oversight here, it's very difficult for a body corporate to bring an action against a developer to actually enforce that stick. There are significant barriers, both financial and practical, when we have the developer controlling the body corporate through powers of attorney and proxies for the first period of the body corporate's life, to actually be able to mount a claim against a developer to claim damages or claim a breach of that duty. There's not one single case since the enactment of the Act in 1997 where a body corporate has brought an action against a developer for a breach of Section 112. And so that's really problematic. So how do we fix it then? Is the panacea disclosure? Do we just simply tell buyers what they're getting themselves into? Are they walking into this completely unknowing of what their obligations are or what the future obligations are? There's already provisions in the Act which require disclosure, and the original owner must, among a bunch of other things, disclose the proposed terms of the caretaking and letting agreements appointments, the estimated cost to the body corporate, and the estimated cost of those contracts to the individual buyers. Many developers will also disclose the anticipated sale price, and that comes off the back of a case in New South Wales where the courts determined that it was a breach of the developer's duty to keep the proceeds of the sale when they hadn't made disclosure. That case is not necessarily applicable to Queensland because we have a different statutory system. So there are already obligations to disclose, but disclosure isn't the panacea because it creates another area of concern. The disclosure materials are drafted on behalf of the original owner by their lawyers. It's time-consuming and expensive. You know, developers can spend tens of thousands of dollars getting their off-the-plan disclosure contracts set up. Lawyers will often use boilerplate agreements, as a basis for those agreements. And that in and of itself is not unreasonable, nor is it uncommon. The problem with doing that is that the documents are generic. And so they will say things like, you must clean the pool if applicable. You must mow the lawns if applicable. How often? What lawns specifically? Is there a requirement to fertilise the lawns? Is there a requirement to take the weeds out of the lawns? Or do they just have to run a mower over it? They're quite generic and they lack specificity. And you can imagine that what a body corporate looks like on day one of its existence is not the same thing that a body corporate will look like 25 years down the track. And that assumes that you've only got one contract period. These contracts have the potential to be indefinite because once the contracts get reduced down to about 8 years for a standard module scheme or 20 years for an accommodation module scheme, the contractor will go to the body corporate and say, can you top it up? Can you give me back the years that I've already spent working here? Because, you know, my financier will require it to be topped up so that I can continue to pay back my loan. So what we see is that lack of specificity and the long-term nature of the contracts can really introduce some significant dysfunction and long-term conflict into these schemes right from day one. So the fact that original owners must tell buyers about management and letting rights isn't a cure-all. If a burden on the property is inefficient or unfair, by telling somebody about it doesn't make it any less inefficient or unfair. It's still just as inefficient or unfair as it was before you told them about it. The only difference is that now they know about it. The question is, can they walk away from it? Can they renegotiate it? Well, if it's the only property that you can afford or there's a lack of equivalent stock on the market, or you're in an increasing property market like we are at the moment where prices are just growing and growing and growing, that becomes a serious problem because you don't necessarily have the ability to walk away and go somewhere else. So when I did our research on disclosure, one of the lawyers in that study commented, and I'll quote what they said, before anything, it's got to be in a form that is comprehensible and digestible no matter what its content. If it's not in that form, then it's inhibited and may be useless. And so disclosure, again, it doesn't fix the inefficiency or unfairness, and it might not even be any good if the disclosure is so complex that people don't understand what they're signing. The consensus from that study was due to the complexity of the contract documents. Most consumers don't fully read or attempt to understand the disclosed information. Multiple experts, as well as buyers, highlighted that the buyers had been sold on the dream. They'd been marketed the lifestyle. And so they were buying into these marketing creations, and the emotion involved in finding the perfect home often clouded their analytical judgment around the disclosure materials, especially when you have people saying, this is standard, sign it up. It's standard for that development, but off the plan contracts between development A and development B can look very, very different. And so it's not really standard. We've had a couple of questions come through. So yeah, so we've got a comment from David that boilerplate agreements, as a body corporate manager, work for a townhouse scheme where their caretaking agreement says they must clean the lift daily, but there's no lift. That's typical. It's typical. I've seen it so many times. And, you know, why do people pay for a contract that's drafted for the scheme when, if it's not drafted for your scheme, if it's using a template? The fact of the matter is that the body corporate is not paying for the document to be drafted. It's the developer that's paying for it. And so if their solicitors say, look, it's going to cost you $5,000 for a perfectly tailored agreement, or we can just throw in our standardised agreement, which will do the job for $1,500, what do you think the developer's going to choose? You know, they're going to go with the more the more accurate, or sorry, not the more accurate one. They're going to go with the cheaper one. So it's really difficult, and the professional duties that a lawyer has to the developer as its client. You're absolutely right. How do you trot out a standard boilerplate agreement? Well, the answer to that, I don't know the answer to that. My perspective as a lawyer was always to make an attempt to make them appropriate. But my experience as a lawyer was as a property development and finance lawyer, not as a facilities manager. And so my ability to say, this piece of infrastructure that's worth millions of dollars needs to be maintained on, this regularly. I don't have that experience to do it. And if I don't have the contacts through the developer to be able to get that, then you use the standard boilerplate document. And that's where the problem lies. So I've mentioned that there's that clouding of analytical judgment. There's also no opportunity for a buyer to renegotiate the terms of these contracts, especially when they're just purchasing a lot. If a buyer walks into the developer and says, I don't like this agreement, change the management and letting rights agreement, then the developer is going to say no. Because as soon as they change that term or that document, they must redisclose the change to all of the other buyers. And if any of the buyers feel that they're materially prejudiced, they can terminate their contract. And so developers, as a matter of practice, do not negotiate these things. And in fact, the study that I'm doing at the moment on the review of caretaking contracts is indicating that they don't even negotiate them for caretakers that are buying the caretaking and letting rights. I had a number of lawyers explain to me that, no, it's a standard document. It's a take it or leave it situation. And so you've got that standardisation of contracts, and you've also got the issue of legal representation. Now, in Queensland, conveyancing must be done under the supervision of a solicitor. You don't get conveyancing firms like you do interstate. However, the retainer for the conveyancing lawyer is often quite limited because those lawyers are operating in a cut price conveyancing situation. And so the retainer looks at the mechanics of the conveyancing or the conveyance. They're not necessarily looking at the provisions of every one of the agreements in the disclosure materials. They don't necessarily advise on the terms of the contract that the body corporate is entering into. And they certainly don't act for the body corporate. So they're not looking at these contracts from the perspective of the body corporate. They're looking at them from the perspective of a conveyancing lawyer doing a transactional arrangement for a buyer. And so the buyers may not be given advice on the implications for them, and certainly not in relation to the body corporate in general. And so then we get back to, well, where do they get advice? And the key issue here is that they might not even know that they need advice. And so we have buyers who may be unaware of the key areas that will affect them on an ongoing basis in this sort of setup. Now, in relation to our study on disclosure, we found that approximately 60% of the respondents that we surveyed, and I should add that there were over 500 respondents to our survey, were less than 44 years old. The largest family composition were a couple with dependent children. So we're talking about young families here who are buying off the plan. Buyers were generally a higher income earners. 50%, more than 50% earned above $2,000 per week. And most respondents were born in Australia, nearly 70% of respondents. 33.4% were in managerial positions, followed by 28% in professional positions. But again, managerial and professional positions and high income earners don't necessarily make you a specialist in strata law. And in fact, of all the academics in Australia, there's only half a dozen of us that focus in strata law. So it's a really narrow specialisation. 53.9% 51% purchased their off-the-plan property as their principal place of residence. And so we're talking about Australian young families who are living in the property. Our study contradicted the traditional view of strata schemes being used as investment properties. That's, you know, a pretty major finding from what we've seen. Nearly 70% believed that they understood the contract very well, or extremely well. But those findings were actually at odds with the literature on disclosure. And also, interestingly enough, when we delved into, do you know what the sunset date means? Do you know what this particular type of clause means? The level of understanding was significantly lower. And so people believed that they had a really great understanding of it, but when you actually got into the nitty-gritty of it, they didn't. And so, you know, that again was fundamentally important. And one of the conclusions that research project found was that the process of disclosing those aspects in off-the-plan contracts should not be considered enough, especially when there's a significant information and power imbalance between the parties. And let's face it, if you've got a developer who's creating everything and getting their lawyers to draft all of the documents, and they have an inside-out knowledge of a project, and a buyer who's getting the marketing spiel, there's clearly an information imbalance there. And as buyers were keen to purchase that lifestyle, they were really less focused on the product elements, which were fundamentally important to them. And that tells me that we have some significant limitations in our disclosure system. All of that aside, we've also got quality issues. Quality of agreement issues. Aside from the quality of agreement issues, we've also got qualification issues. The manager may not even be qualified to do the job. There's no mandated training for caretakers. There are for letting agents. You must have a letting agent's license, and that's managed by the Office of Fair Trading in the same way that real estate agents' licenses are managed. But the majority of that training course relates to things like trust accounting and obligations in relation to letting of properties and accounting for expenses and all of those sorts of things. In Queensland, there's nothing in relation to the facilities management side of things, and yet caretakers are responsible for millions of dollars worth of infrastructure. And so, you know, we've got that real problem there. There's no legislatively granted opportunity to vet buyers of management and letting rights. Once the contractor is put in place, there's virtually no way to remove them except through transfer or termination provisions. And in a second, I'll go through what the termination provisions talk about. There's also no cooling off period and no probationary period. So based on all that, it seems pretty reasonable that competency should be assessed. The question is by whom and based on what criteria? And that, I don't have the answer to that. But that's certainly an issue that we need to have a think about in the future. In terms of reviewing management and letting rights contracts, we've got a provision in there, Division 7, which allows for contracts to be reviewed in the 3rd year of their term, once in a lifetime. They must be set up by the original owner for this provision to apply. Independent review is a positive feature, but the way the provisions are worded, it creates some uncertainty. There's an or in the provisions, which, depending on who you ask, will depend on what interpretation you get. So what the section says is that you can review the functions and powers of the contractor or the remuneration, not and the remuneration. So how do you review the remuneration without also looking at the duties? Or how do you review the duties without also looking at the remuneration? And that's the question we don't have the answer to. There hasn't been a case that has legislatively determined that provision. And then you've got the whole dispute resolution issue. The provision requires administrative dispute resolution forums to be utilised. And in the context of management and letting rights, we have some serious issues with that. So our provisions, you'll remember, came into force in 1997. I did this research late 2019, early 2019. With the exception of one case decided in December 2020, there has not been a single decision made at tribunal level, at administrative dispute resolution level, that has been decided in favour of a body corporate, that has not been overturned on appeal. Every single decision made in favour of the body corporate has been overturned. One case decided in December 2020, which I'll go through in a second. There are issues. If we're seeing legislation in force since 1997, but not one case being decided in favour of a body corporate without having been overturned on appeal, that's a problem. We're seeing something not working here. Okay, so that's the review section. What about termination? The termination provisions are intended to protect management letting rights contractors and their financiers. They give the body corporate the ability to terminate a contract only when certain criteria are met. So forget about everything we learnt about contract law in university. It's all irrelevant because the Body Corporate and Community Management Act sets out what you can and can't do in terms of these contracts. The overarching all of those provisions is an obligation on the body corporate to act reasonably. Now, on the face of it, that seems perfectly reasonable, that people need to act reasonably. It's the interpretation of that provision, however, that has posed some problems. We need to remember here that existing contractors, whether they purchase from another contractor in an on sale of management letting rights or whether they purchase off the plant, are investing a significant amount of money. And it's important that we protect that investment, but it's also important that we protect the collective investment of the owners. And so it's good that we have termination provisions that protect the parties, but what the termination provisions don't do is deal with the situation where management letting rights should never have been established in the first place, and that's on the original owner's back. They do not solve the dysfunctionality that original owners can embed in a scheme. So that requirement for reasonableness has been interpreted at a couple of different levels in QCAT. In Trojan Resorts and the Reserve, Member Brown of QCAT held that it was unreasonable for the body corporate to insist on compliance with a term in a management letting rights contract that is commonly found in commercial contracts, and that was a change of control provision. You must not change the directorship of the company without permission from the body corporate. Apparently, it's unreasonable for a body corporate to insist on compliance with that commercially standard term because the caretaker's day-to-day operations hadn't been affected. That decision was appealed, and on appeal, senior member Stilgo and member Collins concluded that the owners of lots within the scheme weren't required to act reasonably when they were voting at a meeting of the body corporate to authorise the body corporate to terminate the contracts. They could decide to be completely unreasonable and vote yes or no to a motion depending on what their personal views were. However, the body corporate itself had an obligation to act reasonably when implementing those resolutions. So even though the resolution was passed at a validly convened meeting of the body corporate and the owners used their democratic vote to vote for the termination of that contract, it was not reasonable for the body corporate to terminate the contract. I still can't get my head around that decision because presumably the interests of the lot owners would be best served by a contractor who knew and complied with the terms of its contract. And the body corporate would presumably be best, the interests of the lot owners would also be presumably best served by the body corporate following the democratic vote of its members, but apparently not. So Hub Apartments is the only case so far not to have been overturned on appeal, but we still have time, I think. Now, it resulted in a successful termination, but it also occurred in circumstances that were quite narrow. The body corporate reasonably concluded in that case that, based on publicly available information, that the caretaker was at risk of becoming insolvent. And they did that based on an independent report that was provided to the body corporate. It stated that the manager had nothing in its bank account and it was in financial distress. And on top of that, the manager had been under administration for a 12-month period. And so there's really nowhere for the body corporate to go except to conclude that the manager is likely to be insolvent. Now, the manager did not respond to any of the body corporate's requests to provide information around its solvency and didn't really defend its case, from what I could gather from the decision in QCAT either. So the body corporate was reasonable in assuming, or found to be reasonable in assuming, that the manager had become insolvent or was likely to become insolvent. Is it a watershed moment? Is that case going to change the way we interpret reasonableness? I think it's way too early to tell. I also think that, given the pretty clear-cut nature of the facts in that case, I'm not holding out hope. It was a very strong position that the body corporate put forward, given the factual evidence that they had. And so I think that that could easily be discounted as an example of what to follow moving forward. And certainly administrative dispute tribunal decisions don't hold any precedent value. So yeah, I'm not holding my breath there. So back to the original owner. The original owner needs to act in the best interests of the body corporate once it's no longer an owner, but there's no real remedy against the owner to request a review of the terms. The review of the terms in the Act is fundamentally limited, and it's virtually impossible to terminate a contract. So it's no wonder that bodies corporate are crying out, "What about me? It isn't fair." And I dare you not to sing that and have that song stuck in your head for the rest of the afternoon. So law reform is necessary, but what we need to remember is that the voices of the owners must be heard. Developers, the management and letting rights industry, and the finance industry are all very powerful lobbyists, and owners need to be empowered with the same voice. The question of what legislative amendments are actually available also needs to be considered, because most of the current issues that we're faced with today have been caused because of band-aid solutions that, you know, to other, resulting from other amendments. And so if we start from the beginning and rewrite the entire system, we might fix the problems. However, we've then got hundreds of millions of dollars worth of existing investments that are going to be standing there asking exactly the same question that bodies corporate are asking at the moment. And so we need to make sure that we can strike a balance. We need to protect those contracts that are in place, that are already in place, where you have you know, buyers that have legitimately purchased these management and letting rights, and it's unfair to them to lose those contracts. But we also need to swing the pendulum back a little bit to give the body corporate some power back. So more research is necessary. I'm in the middle of part 2 of my research, where I'm looking in more depth at the review provisions. And I'm also doing a project that scopes management and letting rights, and in particular from a manager's perspective, on what their experiences are. But I think until we get to a situation where original owners no longer regard management and letting rights contracts as an income stream for a development, and we recognise, and they recognise, that the contracts bind future lot owners to expensive arrangements for potentially decades to come. We're not going to see long-term change happen. And so while we have very high investments by the management letting rights industry and a high level of risk from financiers who are financing the purchase of these things, we also can't forget the collective investment of owners and the impact that they are suffering, and the the fact that they need protecting too.